today I got some exciting news, super exciting news. And it kind of got lost in the shuffle the past few weeks. I mean, there's a lot of stuff been going on, on top of COVID, um, the GameStop stuff that was kind of hogging the news for the past couple of weeks. But in the world of securities, there was some exciting news that kind of dropped a couple weeks ago that um, no one really saw coming. Well, I mean, we saw it coming, but we didn't know that it was going to happen on that specific day. And what I'm talking about is, there were some recent changes that the SEC put out back in November, some final rules that they released back in November to update uh, private securities offerings. So Reg D, Reg A, regulation crowdfunding. The SEC released new rules that kind of updated them, so to speak. And how it works is, they release the new rules and then it becomes effective. The rules actually become effective 30 days after they're published in the Federal Register. So on January 14th, it was published. The final rules were published. So now we know, sorry, not 30 days, 60 days. So now we know the effective date, which is March 15th. So on March 15th, we know that these new rules are going to go into effect. And to kind of recap what the rules are, what these changes are. I already did a video before, so if you want to, learn more in depth, I guess, about all the little changes that these final rules are going to entail, go watch that video. But to kind of recap, generally speaking, the whole idea behind these rules was harmonization is what the SEC used. So previously, I mean, all of these different exemptions, Reg D, Reg A, Reg CF, they're kind of disjointed. Each one kind of has its own set of rules, and each one is a little bit different as far as what kind of information you need to give to your investors. Whether or not you need audited financials for certain types of offerings versus just reviewed financials. So there was a lot of disconnect between the rules. So the idea behind these final rules that just came out was to harmonize them all, to kind of bring them into one cohesive regulatory scheme to allow companies to basically go through the steps of fundraising, right? So you're a smaller company, you use certain types of offerings, and as you grow, you begin to be able to use other types of offerings. So usually you start off doing a private, Reg D offering, and then when you get big enough, you might be able to do semi-public Reg A, and then once you get really big, that's when you think about doing a full-blown public offering. So that was kind of the thought process behind the SEC when they enacted these rules, is to kind of create this framework for companies to go through this entire process. So to go over some of the important ones that I kind of pointed out and thought would be interesting to our clients and to our industry. So for Reg A, they increased a tier 2 Reg A offering from $50 million to $75 million. So you could raise up to $75 million under Reg A plus now, starting March 15th. Regulation crowdfunding, I think this is probably the most interesting to me personally. They increased the max raise from 1.07 million to $5 million, which is a huge increase. And honestly, a lot of people from the get-go were, that's what they thought it should have been at when they enacted regulation crowdfunding, was $5 million, because $1 million is really not that much. So this opens the door for many different companies to actually be interested in regulation crowdfunding, and maybe even some of our clients that are in the real estate space. That opens the door for them, because there's so many more deals out there that kind of are possible now under regulation crowdfunding, as opposed to before when they were capped at $1 million. So for Reg D, though, I think the biggest one for us is the rule on integration. So integration is basically if you do two offerings kind of one after another, and the SEC says that that really should have been one offering. You're just doing it as two offerings to get around some rule or something. They're going to integrate those two offerings and consider it a single offering, and now you're bound by the more restrictive rules of the exemption that you use. So, for example, maybe you did a 506C offering and advertise, and then immediately after did a 506B offering and didn't advertise. And the SEC says, "Oh no, you did that to get around the prohibition on advertising. We're going to integrate those two offerings, and now you're beholden to the more restrictive one, which says you can't advertise, and you did advertise, and because you did advertise, you lose your exemption. You blew your exemption, and now you sold unregistered securities. So it's a pretty big issue, right? This whole integration thing. Previously, there was a 6-month safe harbor. So if you did an offering and waited 6 months and then did another offering, you are safe. You're in a safe harbor, so that won't those two offerings won't be integrated. That's what the SEC said previously, their previous rule. Now what they're doing is they're shortening that from 60 days or 6 months, sorry, to 30 days. So 1 month is the safe harbor period. So if you wait 30 days after doing an offering and then do another offering, you are safe. You won't be integrated. Your two offerings won't be integrated. That being said, even though they're not integrated, the second offering still has to, you still have to follow all the rules that are required for that offering. So going back to my first example of doing a 506C and then 506B, even if you wait 30 days and they're not integrated because you're in the safe harbor, the 506B offering, the second offering you did, you have to make sure that you did not do any general solicitation. So what that means is making sure that every investor you bring into that offering, you had a pre-existing and substantive relationship with them. So you still have to follow the exemptions, right? You can't, you can't try to trick the SEC by doing a 506C and advertising and then, taking those people into the 506B without establishing that relationship, right? So that's the important thing to remember. But anyways, so those are the changes that I think are the biggest for us. There's a few other ones that are out there, but I don't think that'll affect us as much. But the important thing is now we know the date that these become effective, which is March 15th. So watch out for another video around that time to remind. I'll come with another video to remind you guys of these changes around March 15th. So watch out for that. As always, today is Thursday, so that means Gene is doing another episode of TLG Talks where he interviews someone in the industry. That's today at noon. Go check it out. We're also doing another rookie syndicator training camp, which is going to be 2 weeks from this week, the week of February 16th, I believe. We only have a few spots left, so if you're interested, if you've always wanted to do syndication, but you've never taken that next step to do it, this is the perfect class for you. So definitely sign up if you're interested. You can sign up by going to our website, trowbridgelawgroup.com, and there should be a button up there to sign up. You can also get free consultation with either myself or Gene if you go to our website, trowbridgelawgroup.com, free 30-minute consultation. Anyways, that's about it for this week. Thanks for tuning in, and I'll see you guys next time.